Commissioner Ahmed, if you want to have your seat here, you're welcome to it. And I think that's a good opportunity to address the quorum thing, because this isn't a decision. And I think this is part of why people misunderstand the roles and functions. So 2 commissioners being in the same room isn't a quorum. If we were going to be in the same room and we were going to make a decision about something, that's where we have to pay attention. Can you kind of expand on that? Because even as a commissioner, we should recognize what is a quorum and what isn't, and what is allowed and what's not with respect to seeing 2 people in the same space at the same time.
The Idaho Open Meeting Act is a strange creature. It really is. So open meetings only apply in the county, only apply to the commissioners. They don't apply to me, don't apply to the sheriff, don't apply to the clerk. So we can do anything we feel like in terms of meeting with whoever we want, talk to them, and we don't have to disclose it. If writings occur, they might become public records. So that's a different act, and we might have to disclose those writings. But if we're just talking to people, like if you call me and I talk to you on the phone, I don't have to disclose that to anyone. The commissioners are different. Cities are kind of strange in that regard too. Only the city councils have to adhere to the Open Meetings Act. The mayor, who is in charge of the city technically, does not. So the mayor can do all of those things and not have to be subject to the Open Meetings Act. Why they did it, I'm not entirely sure that way, but it is what it is, and that's what the law is. However, it is only when you are making a decision or deliberating. Okay, well, what does deliberate mean? Well, deliberate means that there has to be something, some issue that you are talking about or actively working on to make a decision in the future. So this gets asked a lot of times, and commissioners want to be safe about it, which I totally understand and support. But they're afraid that if 2 of them are together or 3 of them together, that is a quorum and that they are then deliberating. Well, you have to say, well, what are you deliberating about? You have to ask the easy questions, and if you can't really answer that, you're probably not in an open meeting, and you're not doing a violation. So if they go down to a conference together, if they go to a wedding together, if they do any of those things, they are not deliberating towards making a decision. That is perfectly legal. So just because you see 2 commissioners or 3 commissioners together, that is not a violation of the Open Meetings Act.
Just to shorten it up, effectively, unless there's a motion on the floor, it's not a meeting. You're deliberating on a motion.
I would not agree with that. If it's an issue that is likely going to become before the board, regardless of whether there's a motion or not, and the commissioners that are there are actively taking part in talking or anything like that, regardless of whether there's a motion, that could be a violation.
A good example for you is the Tischler-Buys presentation on whether or not we should do impact fees. There is no decision happening at that meeting. It's informative, but a decision could come out of having received that presentation. Therefore, that meeting was noticed because they all have a quorum, because we could potentially make a decision.
Okay.
This meeting, we're not making a decision, so there's no issue related to that. Is that a good?
So when there is a violation of open meeting laws or let's say executive sessions specifically, isn't it your responsibility and not the Attorney General's who does address these? Thank you.
It is, to the sense that I have to find a special prosecutor, whether that is my colleague in Kootenai County or the Attorney General. I have to then send that to that person. We cannot look at open meeting violations or executive sessions, whatever you want to call it, concerning our clients, the Board of Commissioners.
Would it be accurate to say your role is a facilitator of it, not that you're the person in charge, but you facilitate the investigation into that issue?
Correct. We put together a packet and we ship it to whoever is going to look at it.
But can you kind of expand on narrow scope and executive session for the community?
Yeah. So again, it goes back to kind of the way that our framers here in Idaho piece together county government. And it's interesting, and frankly, it's pretty smart in a lot of ways, but just like we learned back in civics class or government class that there's separation of powers, there's separation of powers within here at the county as well. And there's different branches of government on a local level. but they're mixed. Some of the actors have dual functions, and I'll tell you what I'm talking about. The Board of Commissioners primarily is a legislative body, and as a legislative body, they are clearly subject to open meetings. And by that, you do deal with employees in a legislative sense, in the sense that they are setting salaries and they are setting budgets for the different offices and the different departments. And so in that sense, it has to all be out in the open. However, because certain departments fall under the Board of Commissioners and not the sheriff or me or the clerk or any of the other elected officials, they're not acting in a legislative sense when they're dealing with their own employees. They're dealing in an executive function at that time. And so when you're dealing when they're dealing with an executive sense, they're dealing with individual employees, those things should not be out in the public, and they're not subject to Open Meetings Act. Also, when you're talking about the Open Meetings Act, and with executive sessions and just other violations, there are a lot of times it's a cure. If they acknowledge what they did or the decision they made was wrong, they can come back and cure it. And a lot of times that works, and that's always our advice, is really to be safe. Unless we think a clear cut is not a violation, we recommend that they just cure it, which, there's some political capital that they have to decide, but legally that's the best move, is to just say, hey, wait, we may have made a mistake here and did something that wasn't agendized properly, or we shouldn't have been in this executive session. We're just agendizing it for the next meeting. We'll do it in public. And that cures it, and that sort of obviates or stops the need to send it out for prosecution. Because the goal of the Open Meetings Act is for the people to have part in the decision-making process. It's not to, prosecute or give civil penalties to county commissioners.
So you give advice, and if it's egregious, you get a special prosecutor. Is that correct?
That is correct.
So letters to you would be able to kick into play that process of getting a special prosecutor. Is that correct?
Yes, ma'am. That is true. You can also contact the Attorney General, but you will likely get the response back from the Attorney General that he does not have jurisdiction. So a lot of times I think people may be frustrated with me or frustrated with the process, and they think, well, I'm going to write the Attorney General and he'll look at this and he'll take over. And I think they're probably disappointed because they get a letter back saying, I don't have jurisdiction, ma'am. I'm sorry, you need to contact your county prosecutor. And they're like, well, I hate Marshall and he doesn't do anything anyway, so I'm stuck here in the Netherlands. I have nothing I can do. There is really nothing. And that's not true. I do listen. It's just, again, we have to have evidence of wrongdoing. And there are so many complaints right now that I can't tell you about them all because, a lot of them are confidential, but there's so many complaints coming in on so many issues that we are kind of overwhelmed with this. One of our jobs with our boards is to basically not tell them what to do again, but to be like, hey, you're getting a little bit adrift here. We went in under personnel to talk about employee A. We're now starting to talk about budget issues. We need to stay back on track. So it's the function of the attorney, but when you're talking about small districts, it's a much more difficult issue. The only thing that I think you can do as a member of the public is, again, make the complaints to the board first, to that board, and say, hey, you were in there for 3 hours. You're forcing us to sit out in the parking lot. How can you possibly be talking about this one protected issue for 3 hours? And hopefully those board members will recognize this is an executive session is not a license to just start talking about whatever they want to talk about.